I welcome you to yet a fresh edition of Law and You, where we take our time to look at the nitty-gritty about the law, and it's for the purpose of deepening knowledge on what the law is, the perspectives, bringing you different sides of it in order to make sense out of it. Today's topic is centered on the issues concerning the petitions of the presidential polls that happened February 25th this year, 2023. And these petitions have been x-rayed by the Supreme Court, and it gave a ruling agreeing with the counts that were already given by the Presidential Election Petition Court in September 6th this year. And looking at that, various parties, the parties in question, the PDP and this presidential candidate in the person of Alhaji Atiku Abubakar, and that of the LP, Peter Obi, they all also had their criticisms in this direction. We'll be bringing you that as the show progresses, but discussing this vital issue with me is a legal practitioner, as we always take our time to have a legal practitioner to draw the perspectives and analyze issues as they come. And he is Andrew Bello. Good to have you join me, Andrew.
It's a pleasure being here this afternoon. It's a pleasure.
All right. Well, let's look at what transpired in the course of the week, and the aspect of, let's look at what transpired in the course of last week.
Yes.
And the issues raised by the Supreme Court in the ruling that agreed with the counts of the Presidential Election Petition Court for September 6th.
Yes, the Supreme Court made the job of the Presidential Election Petition Court, that's the Court of Appeal. It simplified, it gave us a summary of what that court did. I think the Supreme Court basically aligns with the Court of Appeal in most of its rulings, even though some of us have reservations on the judgment of the Supreme Court. But it is the final court of the land. It is the Supreme Court. Its judgments, its decisions are final. They are not infallible, but they are final. Now, the summary of that judgment is this. One, according to the Supreme Court, Abuja does not enjoy any special status when it comes to counting of electoral votes. Two, the issue of forgery was not proven against the president, the incumbent president, as declared by INEC. Three, on the whole, the petitioners did not prove their case, in that IREF, which they were relying upon, according to the Supreme Court, IREF is not a computing system. It's not the collator of electoral results, if I may use that word. Now, it's not empowered to collate electoral results for the elections. So in the summary, these are the basic issues touched, but there were small other issues here and there. But somewhere along the line, the Supreme Court agreed that the failure of INEC to use IREF to collate results reduced the confidence of the people in the election. But the problem is this: that statement does not help in any way. It's a mere statement. It's a mere obiter that was spoken by the wayside. It does not have any effect on the decision given by the Supreme Court. Now, you will hear lawyers who say the decision was very sound. Yes, it was sound in law. My question, which I've always asked judges and lawyers everywhere, is sound according to which law? To whose law? Because the issue is this: we have two types of law. The substantive law, which is the law that the people know, the people obey, the people are duty-bound to obey, and the procedural laws, which are the laws that we operate in courts to get to interpret those substantive laws. So if you have issues and you go to court, you are coming to court to deal with the substance. The issues that brought you to court is the substantive law. That's what you are coming to court to look at. Meanwhile, we the lawyers will be looking at the procedures.
Yeah.
What procedure did we follow? Are we supposed to follow to get these issues resolved? That's where we say there are two types of the law: the substantive law and the procedural law.
Which is weightier?
The substantive law has always been weightier,
as it implies.
Right from the days of Genesis. The substantive law has always been weightier.
So it takes preeminence?
It takes preeminence.
Okay, but did you see the substantive law playing out
in Nigeria? You know, when we want to do things the way we want to do it, we now begin to look for substantive law, procedural law, adjectival law, we begin to give it prominence, we begin to give it special pride of place. Because the truth is, what the man on the street wants to know, did this man steal my phone or not? That's what the man came to court for. He didn't come to court to look at, oh, the lawyer did not agree his case, well, let him take the phone and go. I'm looking at my phone that was stolen. We have all seen that he stole it. There's evidence that he stole it. But the procedure for which to bring that
establish the truth,
to establish was not followed. So the man should go with the phone. That's where we seem to be tilting towards as a people. And this is not, it will not be in only this presidential election petitions alone. We have seen them happen over time and again whenever issues relating to persons of substance, persons of prominence are being dealt with. I'll give you another example. Now, the P&ID judgment had just come out now from the United Kingdom. Yeah. And we are here celebrating it because it came in our favor. But if you look at it, if that judgment was given in the Nigerian court, there's 99% certainty that it will have gone the other way. Because if you look at it, substantively, it is in our favor. Or procedurally, it is not in our favor. What do I mean? The persons who drafted those agreements, the P&ID agreement, majority of them were Nigerians. Nigerians had input. The short it was Nigeria. If you look at the judgment of the UK court that gave us, the court that now gave us victory now that we are celebrating and jumping, people have not read the judgment to see how they lambasted Nigerians. Over 6 Nigerians were mentioned and lambasted because of the role they played. They were people of prominence, people of power, people of authority in Nigeria at the time who connived, to use the words of the court, the British court, they connived, they colluded to rip this country, to rip Nigeria of its resources. They just went there in the name of, they were drafting contracts on behalf of Nigeria. They were supposed to be representing Nigeria in the contract. They were supposed to be representing Nigeria as Nigerian experts, Nigerian representatives in that contract drafting. You know, if you want to buy something from another company, you send, as a company from here, you send your representative to their company, you hold a meeting, you hold several meetings, you draft, you come together with at the end you come up with the contract. That's what was done in that P&ID case. Nigerian top brass, I don't want to mention names. If you look at the judgment, they are there. People who hold prominent positions were given power to go and draft agreement on our behalf, to go and enter into agreement on our behalf. They went there because of kickbacks. In short, the court said they were taking, they were being paid by P&ID. They were supposed to be representing Nigeria, but they were being paid by P&ID. So because of those kickbacks, they put Nigeria in a very bad contractual light, such that at the end of the day, Nigeria was meant to pay billions for nothing. Okay, back to the subject. Now, bringing it back to the subject. Now, that is exactly where we are right now in our judiciary. We just give out judgments, but we don't look at the far-reaching implication. Okay. Because if you allow a person whom there is evidence that he has taken something that does not belong to him, they say this thing does not belong to him. So ordinarily, the people have come to court. The reason they came to court is for you to declare that, oh, there's evidence that it does not belong to him. Declare it so. You now say no, the type does not. I'll give you an example. Now, the Supreme Court judgment of 2 days ago, the one we're talking about, the one in focus, said the time for introducing evidence has passed. They didn't say there's no evidence to be introduced. They didn't say, oh, this evidence, we have looked at it, it is not sufficient, or it is no evidence. They say the time for introducing evidence has passed. So to that extent, we cannot take in this new evidence. Okay, but looking at it by law, has it passed? Yes. That's why I say procedurally. The procedures, the law that guides how you bring in evidence, by that law, it has passed. So technically, it lacks merit. Well, the judgment was very sound. Because we read it, you know, according to what was said in the ruling. Yes. You know, the apex court denied the PDP and his candidate, you know, presidential candidate, of bringing fresh evidence. The reason they denied him, if time has passed, yes. Does it mean that it can never be we can't go into that anymore? That's what it means. Because you may mention of the fact that the rulings could be final. They are final, but they are not infallible. Yes. If they are not infallible, means so if they are not infallible, it means that at what point can it be reopened? It cannot be. The word infallible I use is, as a common man, as an ordinary man in my house, I can begin to pinch hole into those judgments in my house, but I cannot go to any court to challenge them. Okay. Because they are final. That is the top. That is the highest court of the land. There's nowhere in the world that I will go today and file fresh petition and say, let's challenge what happened in the election. It has ended. It has ended.
So it has been nailed.
It has been nailed finally and buried. So that issue of going to court to argue the petition issues surrounding that election has ended permanently.
So which means if we are looking at evidences or if we are looking at operations of the law in terms of litigations in court,
yes,
it's not just the judiciary or the court does not really emphasize on establishing truth, but the procedures.
Our courts, don't say the courts, you say our courts, as presently constituted, seem to have dealt so much on technicalities, on procedures. You know, when you want to, when you already have an answer of a question, but you want to reach the answer, you want to reach a particular answer, you look for the answer, the procedure that will take you to a particular answer. That's how it is. I have always said, judges are human beings. That's just the plain truth. Let us not deceive ourselves. Judges are human beings, subject to all the idiosyncrasies of man. The way I want to get more, that's the way a judge wants to get more. The way I believe that I am superior, I should be entitled to more. That's the same way a judge believes, even though it should not be. But that is where we are today in the country.
So are you saying that innate human intention,
yes,
they played out?
Yes, they played out. As far as I'm concerned, they played out. I'll tell you why I say they played out. Over the years, President Goodluck Jonathan was the first person to cry out during his days as president that we are sliding gradually into an erroneous path where judges now interfere. They now determine who becomes what in politics. When President Goodluck Jonathan was in power, he raised that issue for the first time, that judges were now being interfered with by the politicians. And we have since cried, Nikitobi had cried that the distance between politicians and judges should be very far. There should be this very wide gap between the judiciary and the executive. They have no business, the executive and the legislative arm on the one side being politicians and the judiciary on the other arm. They have no business. They should keep that distance amongst themselves. But over the time, over the years, we had them coming closer and closer. Under President Goodluck Jonathan, we had the president of the Court of Appeal who was deciding over a lot of the legislative matters, a lot of the matters from legislative tribunals. For election tribunal with regards to legislators ends at the Court of Appeal. So the Court of Appeal was presiding over a lot of matters. They don't get to the Supreme Court. That's such that when they give their decision, it does not align with Supreme Court position on those issues. And the Supreme Court was not so happy with it. And the Supreme Court promoted the head of that court, the Court of Appeal there, to come and join them at the Supreme Court. Let the person come and join them. Let somebody else become the head of the Court of Appeal. The man said, no, sir, I will not live here, that I'm a head of court. And as such, head of courts don't get promoted. So who said so?
And he had his way?
No, of course, had his way where? The court eventually, the NJC being what it is, being the highest body regulating judges, had to ask him to step aside since he would not be promoted. If you are promoted, you don't want to go, then you step aside. And he was removed from his office as president of Court of Appeal. Another president was put there. But from that time till now, that attitude of interfering between executive and judiciary, it has widened, it has broadened, it has blossomed. To the extent that under President Buhari's era, President Buhari's regime, the NJC suggested names, because the procedure for appointment of judges is the NJC will nominate and send to the president for appointment. The NJC nominated persons for appointment as judges of the Federal High Court, whom the JROP, Justice Reform Project, and other like-minded, forward-looking NGOs petitioned. They said, no, these people, the president should not assent to these people's appointment because majority of them are family members of politicians and judges. And we cannot continue like that. We cannot have a system where the wife is a judge, the husband is a governor. The wife is a legislative senator, the husband is a judge. It does not make sense. That is having judiciary and legislature, judiciary and executive in the same bed. And you know what happens? The decisions that are supposed to be taken separately with wide gap are not taken together. A judge's decision is supposed to be sacrosanctly taken personally without any interference, fear or favor. To the extent that what we were taught when we went to law school is that if there's a likelihood of bias, it's not like there's bias, likelihood, the person should recuse himself, the judge should recuse himself. Okay. That's how
if there's any slight allegation.
Yeah, that's how much the gap should be.
Okay.
Such that if a judge, it may not even be the judge, if there's a judge in that court that has familiar relationship with the party, that matter, depending on how it is, it should be taken away from that place and taken to another place, so that the gap will be seen to be wide. Not when you have a judge sitting in a court, he's giving this, you have a president of the Court of Appeal now, or a president of the Court of Appeal then, Justice Bukachua, that the husband came out on air and said, I thank my wife for the assistance he gave to me and my friends. He didn't give any good impression of the judge. The judge may not even have had anything, but whatever the judge have done or not have done has now been overtaken by the statement of the husband that I thank my wife for what she has done for me and my friends with her office. See, you have put that office, the entire office, the office of the Court of Appeal, President of the Court of Appeal, a very important office under the legislature there. You have not put that office as if it's the bedfellow of the legislature, that they can just be hobnobbing together. All right. Recently, again, we also saw on TV at the opening of the new legal year in Abuja, I saw justices of the Court of Appeal lining up, queuing up to go and shake the hands of the Minister of the Federal Capital Territory. He's a life bencher, I agree. He's a lawyer, I agree. But for heaven's sake, he's a politician for this purpose. There's no reason why they should be shaking his hands first. Let him line up to go and shake his hand. He should line up. He should be the one lining up to shake their hand. He should be the one finding ways to shake their hands. But we now have judges who now feel that it is okay.
So what you're saying is that there seems to be a hobnob between the
judiciary and the executive,
which could also have its negative outlook in terms of the decisions that are taken by the court.
Yes, because now when the court gives judgment, people are supposed to look at judgment of courts from the perspective only of the law that is before them. That's how we're supposed to look at it.
Yeah.
But now when you now look at what has happened outside the courts, you now bring it to what is happening inside the court, you see that it's as if the court is now part of the executive, the part of the politicians. The judges that are supposed to keep a very wide gap, they are supposed to be in a cocoon, a separated cocoon from the executive and legislature, they are now having a romance, a relationship with these people, and it is not healthy for our system.
In case you're just watching, it's Law and You, and we are looking at the ruling of the Supreme Court over the presidential election petition of the February 25 polls that took place this year, 2023. And I've been discussing with a very articulate and erudite legal practitioner, Andrew Bello. Let's stretch it a little bit. Let's look at the saga about the 25% votes, 25% number of votes that should be won by the one that will be declared by as a winner in the election.
Yes, that's your 25%.
How do you see the description?
It's purely a matter of law, not of fact. It's purely a matter of law. Now, and when it comes to pure issues of law, the judges are the experts, or they are supposed to be the experts. The law says the vote cast in 25 the person must secure 1/4 of the votes cast in 25% of the states and the FCT. Use the word and the FCT Abuja. The question is that FCT Abuja separated from the states, the 36 states, or is it part of the 36 states to make 37 states? The Supreme Court has said for this purpose, it is a 37 states for this purpose. Not for other purpose, but for this purpose of collating votes.
So that has been established
by law.
So based on the decision of the court.
Yes, anytime in future. You know, before now,
reference can be made in future.
Before now, we've never had that issue come up because no president has ever been president of this country without winning 25% of the votes in Abuja.
Okay, so this is a unique case.
This is a unique case. This is the first time it's happening, and it's unfortunate we're having a president that, as we speak, that's the plain truth. Let us not deceive ourselves. Whether the Supreme Court has confirmed it or not, he does not enjoy majority of the confidence of majority of people in this country.
Well, the court has ruled over that.
Yes, he has an uphill task.
That is no longer tenable.
Yes,
what you just said. Because the court has ruled over that.
The court has ruled that 25% of the vote in Abuja is not mandatory. It does not mandatory require it.
It does not stop, and it does not stop the president, the candidate of the APC
from being
declared as winner.
But that does not mean that he won that. He didn't win that. He didn't win Abuja.
Well, that is not
that one. But that one is not an issue. The only issue is that the Supreme Court has now ruled that no president requires Abuja to win that seat. Okay. It's a matter of law. It has been settled.
Okay, but going forward, how do we make the rulings more acceptable, yes, and also reflecting truth?
Yes. Now the thing is this: people will always find a way to refuse what they do not accept. We may come before you and bow down and say, "Oh, we accept this." We come before you. We are fully with you. When we go to our inner closet, we begin to say what is in our heart. And it is that one that is in our heart that will act out when the opportunity is given to us. So let us begin to, as a system of justice, let us begin to look for how do we buy the confidence of these people. What are we not doing that is affecting the people's confidence in us as a system of government? Because the judiciary is supposed to be a system of government, a separate system, not the one where as if we are not part of the executive. No. It should be a separate system. That system, the job there is go and interpret law and nothing more. Now, what do we do to get that confidence? That was the question you asked me. It's very simple. It is all of us that are going to do it, not the judiciary alone. Because the judiciary, as it is right now, somebody was telling me that the executive have their neck on the judiciary. I say it's not true. They have their knee on the neck of the judiciary. I say it's not true. Nobody is holding the Nigerian judiciary captive. I will say that one anywhere. The Nigerian judiciary is as free as any part of any aspect of government in Nigeria.
So you mean the judiciary has independence?
The independence of the Nigerian judiciary is not a contest at all.
Okay, as of today,
it has never been a contest. It has
never been a contest.
The problem with us is our greed. There's nobody that is holding our judiciary to ransom that refuse to accept it and agree.
So what they're saying is that if there is any element of executive influence, it's as a result of the greed.
Thank you.
Of the
the person involved at that time.
Okay.
It's not because the executive is pressing.
Okay.
Because when you mean pressing, it means that you have given the judgment, the executive refused to obey, or you have done your job and they not fired you.
Okay.
I don't know of any judge that was fired because he gave a judgment that the executive did not like or the legislature did not like. So, if you ask me, that attempt to push blame and say, "Oh, the judiciary is under chains," it's not true. Our judiciary is not under chain.
Right,
what we will do to set our judiciary, to give confidence back to our judiciary, is for all of us to begin to put our eyes in the process of appointment of judges. You, as a journalist, you should be interested. The medical doctor, NMA, should be interested. NUJ should be interested. NBA, heavily interested.
Various unions.
All the various unions, they should know if there's going to be an appointment of judges in Edo State, for example. I don't see anything wrong if the leadership of these unions go as a leadership to the JSC office.
But we have all of this in the NLC.
The NLC, leave NLC out of it. NLC has become a political organization, so I don't want to even go there. This leadership, if they come together and say, JSC, you want to appoint 10 judges in Edo State, okay, what is the procedure you are using, please? Who are those who are eligible? What process are you following to get those eligible ones? What criteria must they meet to be eligible?
So with all of these unions coming together, things we get.
Yes, people should begin to ask questions. We should stop folding our hands.
All right, thank you.
And waiting for bread to be delivered to us.
Thank you. It's been awesome having a very beautiful chat with you on this episode of Law and You. Big thanks. And that's how we call it a wrap onto this episode. Do well to join us same time next week. But I promise you, we're going to be having an extension of this particular topic treated in this episode in our subsequent editions. I am Philip Omo Gupon. Till I come your way again same time next week. Is bye.